Okay. Okay, gonna reset my notes here. All right, back to corporate law, and we have a new chapter here. All right, Professor Seth Orenberg, and now we're moving into shareholder voting. Shareholder voting, chapter 14. So shareholder voting is actually really interesting for people that care about voting generally, because a corporation has been referred to as a microcosm of a country. It's sort of a private constitution you could think of. And we have these sort of entities that exist by virtue of states. They exist sort of within states. They're subservient to the states and exist by virtue of them. But then they get their own independent existence, and they operate in ways which are governed by state statute as well as by their own internal documents. And so we have this interesting mix of sort of almost constitutional type principles that we see at work here, combined with very strong statutes and contract law, because at the end, a lot of this is what we call private ordering, where businesses are allowed to set up their own affairs. So, how do shareholders protect themselves? Three basic ways. Sir?
Vote, sue, sell.
Vote, sue, and sell. And what are we talking about today?
Voting.
Voting, right? Right. Well, we talked a little bit about suing the company. Later we'll talk about shareholders suing the company, right? Today we're talking about voting. And so voting really comes in four flavors, right? Well, I shouldn't say that. We're covering four kind of areas. First, we're going to just talk about the basics. We're going to cover, at least today, we're going to cover the basics. And then shareholders have rights to approve or veto certain corporate actions known as fundamental transactions. I want to point out the outset, I would write this down, I would make a note, I would get into your head. Fundamental transactions refer to fundamental corporate changes, not fundamental business changes. You'll see what that means in a minute. Fundamental corporate changes are when a company changes its corporate structure in a way which is specifically referenced by statute as requiring a vote. It is not the same thing as Microsoft saying we're not going to sell Windows anymore. Microsoft I think 90% of its revenue is from selling Windows. And yes, if Microsoft said, you know what, we're going to stop selling Windows and we're just going to make laptops, that would be a fundamental change in a common understanding of the word fundamental change. But it is not something that's going to get us a shareholder vote, because we are looking at fundamental corporate changes, structural changes. And we're going to see kind of four main categories of those. Shareholders do have limited powers to initiate actions, right? So they have their approval veto powers, they have their initiative powers, and boards have some mechanisms that they will use to respond. And here we get into sort of a whole other area about corporate takeovers and poison pills and hostile takeovers and matters like that, which are kind of, in a sense, beyond the scope, but we're going to get an introduction to it. Very hot area, an area which has a very, very exciting corporate area for those that want to pursue kind of the more litigation aspects. Who are shareholders? What's that mean if you're a shareholder? What are you in a company? So you're an owner without control. Now this is a concept that we don't see in too many other places in our day-to-day lives. But it's important to remember throughout this that shareholders own a company collectively, yet they don't control it, at least not on a day-to-day basis. They have limited control and management rights and limited roles in the corporate governance process. And their role is limited, again, as was said, to voting, which is, and I'll reiterate, approving fundamental transactions, which we'll define in a minute, essentially mergers, asset sales, which are similar to mergers, dissolutions and charter amendments, initiating certain actions, like amending the bylaws, making recommendations, something called precatory proposals, removing directors for cause or for not for cause. And then later in this semester, we'll talk about rights to sue. The rights to sue are enforcing their fiduciary rights through what's called a derivative suit, and protecting their own rights through either a class action or demanding disclosures, appraisals, and inspections. And then selling means literally selling your stock, and that requires there being a market for it. Now, while we're not talking about selling stock today, you'll see that the ability to sell your stock actually changes your rights in terms of voting and appraisal. especially in Delaware. We're going to learn a concept called the market out exception, which basically means that if you have the right to sell your shares and the ability to sell your shares in a very easy way, you lose some of your protest rights. These rights are designed, these voting rights are in part designed to protect shareholders that would otherwise get trampled, and we don't feel that that's as necessary in a public company context where shares are liquid. So selling and voting actually gets commingled in this section. When do shareholders have meetings? When do shareholders get to have meetings? Annually. They have meetings annually. Now, I can tell you this firsthand. I represent a bunch of companies that don't have annual meetings. They just don't do it. Am I violating my duties? Is that illegal? Why is it that I would represent companies that don't hold annual shareholder meetings? Are annual meetings required by law? Does Delaware law say you must have an annual meeting? What does Delaware say?
Just that any shareholder can force a meeting?
Any shareholder can force a meeting if one has not been held within 15 months. It's not something you have to do every year. It's something that you have to do if the shareholders demand it. Now, if you're the sole shareholder of a company, you're going to force a meeting? There are other ways to get things done. Right? Public companies generally do hold the meetings so they can hold it on their terms as opposed to when they're forced to do it. So public companies, large companies, widely held companies, generally will have annual meetings at regularly scheduled intervals. But some companies don't have them at all. And some companies don't have them until they're forced to. So that's one way shareholders can have a meeting. What happens at the annual meeting? What's the big event at the annual meeting? Electing directors, right? That's the number one thing. A couple other things happen there too, but annual meeting, electing directors. In addition, can shareholders have meetings aside from the annual meeting?
Sure.
And what's that called? It's right here.
Oh. Special meeting.
So tell me what a special meeting is, how that works.
Basically, a shareholder wants to have a meeting to get something done, something other than what they would do.
So shareholders can also demand a special meeting for a particular purpose. Now, the rights of shareholders to demand a meeting comes from where? Where does that right come from? Where can it come from? There can be different sources. Where can come from the bylaws? Charter maybe. So those are voluntary. So a company could either do that or not do it. So do shareholders have any inherent rights that cannot be waived to have a meeting? And where would that come from? Where do shareholder rights come from generally, aside from the bylaws and the articles?
State law.
From state law, from statute. Right? And so it'll depend on the law of the state that you're operating in. Now, most large public companies are incorporated in Delaware. In Delaware, shareholders cannot demand a special meeting. Maybe this is a reason why companies incorporate in Delaware. As we see this process, if we see the difference between what it's like to be a Delaware company versus a not Delaware company, we start to think about why Delaware? Do companies want to give their shareholders control or not? Now, this is a long-standing debate about corporate governance, and it's an interesting and complicated debate because the price that people will pay for stock does seem to vary depending on how much control they have. Or at least we have seen correlations between either giving shareholders more power or taking that away and stock price movements in the aggregate that have some empirical basis for us to think that there is a correlation between shareholder rights and stock price. Now, it's not entirely clear who makes the decision about to incorporate in Delaware. Sometimes it's the stockholder, sometimes it's the underwriter, sometimes is the management. So as we'll see through this, just think kind of on a high level. This is not a class on corporate governance, but this section is. This is corporate governance. You know, why certain laws preference certain types of stakeholders in a company. So Delaware, for example, and we'll see that in terms of comparing, we're generally going to compare the Model Business Corporations Act, which has been adopted by, I think, a plurality of the states, if not a majority, but it's the most common form of not Delaware statute, and we're going to compare it with the Delaware statute. Now, in addition to the law, in addition to the statute, Delaware has another feature that companies like. What is, well, there's a couple, so you can name a couple. What else, so other than an obvious preference for the statutory background that forms sort of the rights of shareholders. What else is appealing about Delaware? Any ideas? So one thing Delaware offers that Pennsylvania, for one, absolutely does not, right? In Pennsylvania, every judge, every state judge is elected. And we don't have specialty courts. In Delaware, we have appointed specialty chancellery courts that deal only with corporate matters. And so when you have a corporate legal issue in Delaware, under Delaware law, it gets reviewed by pure corporate experts who are the leading jurists in corporate law today. They are also better at resolving the issues quickly and in a streamlined way, because uncertainty in litigation is like a dark cloud that hangs over corporations and really stops them from raising capital, from doing business, from entering into deals, et cetera, et cetera. So the ability to resolve issues quickly and with the best judges that are technically, theoretically available. Now, this is not as democratic as Pennsylvania's system, where we vote for our judges, and there are costs and benefits to each system. You can study Pennsylvania constitutional law and think about what it means to have elected judges versus appointed judges and whether this is good or bad for society. But corporations seem to like it. So at least as far as corporations go, they seem to like to have these appointed specialty judges. And I can tell you on a first-hand basis, the Delaware Secretary of State that does the filings, they make it easy. They offer expedited. You can get something done in 2 hours. I filed a notice in California called a 25-102-0 notice. It's a very simple notice. It's a page long. And I filed actually 2 notices. A statement of information basically saying that the directors of a company did not change this year. Right? I checked 2 boxes. I listed the name of the company. I put their address. I said, nothing has changed this year. And at the bottom, I've already given you what's it called? Power of attorney, right? So you can file this, right? I already have that on file. And in addition, I filed something called a 25-102-0 notice because we made more stock available in an option plan. Okay, these are very simple documents. I called and asked, what's the status of them? I filed these in California. They're California requirements, so the company does business in California. And I called the California Secretary of State because the company is going through a diligence process, going over review. And I said, I need these documents. I sent them to you 11 days ago. And they said, well, we don't really work that way. We can't give you an update. And we don't have any documentation to show that you even filed it. And we'll sort of get to it when we get to it. Now, that's not a great answer. So then I have to call opposing counsel, investors' counsel, and say, look, I know you want to see the 2502 notice. I know you want the statement of information because these are part of your diligence process. You want to make sure we're following our corporate formalities. I did it. I'll stipulate to it, but I can't do anything. And I can't expedite it. On the other hand, Delaware, if you pay an extra $600, they'll do it in an hour. So that's just easier, just better. It means if I need something done, I can get it done. And when it comes to a merger, anything that has to happen quickly, having 1 hour, so those kind of things turn out to matter. And so it's actually like a business. I mean, Delaware operates like a business, and they get a lot of tax revenue for it, and they make things easy. Okay. Shareholders can act in a third way. They can act at an annual meeting, they can act at a special meeting, and they can also act through a written consent. What is a written consent?
It's when they get, I guess, however many people they need to sign off, they decide to do something.
So how many people do they need? And I think you said something. Don't say what you. If I heard you, don't not quorum, right? The term is not quorum. Quorum is a meeting-specific term. What is a quorum? A quorum is the number of people you need to hold a meeting. So the concept of quorum does not apply to a written consent because there is no meeting. It's just a threshold to being able to have a meeting. So what do you need to get a written consent approved? In Delaware, a majority. In some states, unanimity. Can you imagine how hard it is to get every single shareholder of McDonald's corporate to sign something? So, again, Delaware makes it a little easier. By the way, when we talk about a majority, let's say there's, well, I don't even write this on the board. Okay, if there's 100 shareholders, right, and they each have 1 share of stock, what constitutes a majority? No. We have 100 shareholders, each has 1 share of stock. What constitutes a majority? 51. 51, right? We have 100 shareholders. One has 99, let's say we have 100 shareholders. One has 1 million shares, the rest have 1. Okay. What constitutes a majority? How many shareholders constitute a majority? How many shareholders constitute a majority?
I'm sorry, could you repeat that?
One shareholder is 1,000,000 shares. 99 shareholders have 1 share. How many shareholders constitutes a majority of shares?
Or it depends.
Doesn't depend. One, right? The one with 1,000,000. We're looking at number of shares, not number of shareholders. If one shareholder is 1,000,000 shares and 99 shareholders have 1 share, that one shareholder alone can do the written consent all by himself. Anyway, this was meant to illustrate the point, and maybe a little too obliquely, that we're not counting number of shareholders, we're counting number of shares. And that may be one shareholder, that may be half the shareholders, that may be some other number in between. But we care about the number of shares, not the number of shareholders in most of these cases. So what do we need to have a meeting? Well, we need notice. This is for a special meeting. For an annual meeting, we typically don't have the notice provisions because they're if they're regularly scheduled. So regularly scheduled meetings, this is for special meetings. Shareholders are entitled to written notice at least 10 days in advance, but usually not more than 60. Again, this depends on state law. It can also be changed in the bylaws, although usually the state law is sort of the minimum, or at least sets the outer bounds, and then the bylaws can do something more specific. Which shareholders are entitled to vote at a meeting? How do you figure out who's entitled to vote at a meeting? Yes?
Would that depend on the bylaws?
Well, it sometimes, but there's a very common statute. So, okay, the default rule under statute. So, under Delaware statute, under most state statutes, how do you determine which shareholders are permitted to vote at a meeting? So we introduce a concept here called a record holder, right? A record holder is people that own shares on a record date. We set a date and time. We say on November 1st, we're going to count the shares. Now, we do this in advance of the meeting. After the record date, before the meeting, shareholders can change, right? Let's say on November 1st, I own 1 share of International Blimpie Corporation. I'm entitled to vote at the meeting even if I sell my stock before the meeting. I sell my share to you on November 3rd, after the record date. You're not a record holder for the purposes of this meeting. So we count the shareholders that are entitled to vote on the record date, and we tabulate them as record holders. It sort of fixes the date, and then we know how many shares are outstanding, who's entitled to vote, who we have to get votes for what. That gives us time to sort of plan and prepare and know what votes will count. We don't wait until the last minute. We have this record date concept to determine who can vote at the meeting. How many shareholders have to show up at the meeting? Ms. McGee, you should know this one. How many shareholders have to show up at the meeting? A quorum. Awesome. And what's a quorum? A quorum is just that. It's the minimum number of people required to hold the meeting. Now, we have a quorum rule that pertains to directors. We have a quorum rule that pertains to shareholders. They're a little bit different. To have an effective meeting of directors, we have to have a quorum present for the entire time. To have an effective meeting of shareholders, we only need a quorum to begin. In part, that's just because there's usually a lot less directors than shareholders. So I think the example I gave, this actually literally happened. I was on a phone call, and a director said, excuse me, I got to use the bathroom, and I had to say, we got to stop the meeting for a minute until he gets back. You don't do that in a shareholder meeting. You don't have to do that in a shareholder meeting. Your quorum is sort of fixed at the beginning. But you literally, it's almost like you have a guy in the front who's clicking a button. 1, 2, right? You hit 784, and you start the meeting. Now, that button that I'm thinking it's a little theoretical. Because again, you're not counting shareholders, you're counting shares. So I walk in with 1 share. I walk in with 1,000,000 shares. I count differently toward the quorum. The quorum is counted. With directors, we count the people. With the shareholders, we count the shares. That make sense? So we count the quorum, we count the votes based on the number of shares, not the number of shareholders. We could have a quorum with 1 shareholder. We might have 1,000,000 shareholders in the company, right? And they each have 1 share of stock. And one who has, or 999,000 shareholders, right? 999,999 who each have 1, and 1 who has 1,000,000. Not only can we not start the meeting until that 1,000,000 shareholder walks into the room, but technically that would constitute a quorum such that only he needs to be there to have that meeting. Very different from how we think about director voting. Very different how we think about attendance at a meeting. You're attending not as yourself, but as your shares. And as a result, you can attend not even by yourself, but by proxy. But I'm getting ahead of myself. Okay. A couple rules to know. The default quorum in most states is a majority of shareholders, but Delaware, again, makes life easier. The minimum number of shares for a quorum in Delaware is a third. So we're going to see, as we go through this, that Delaware makes corporate governance easier on management, at the expense, potentially, of shareholder rights. All right, proxy voting. I don't have to walk into that meeting. I can send someone else to do it for me. Can directors do that? Can directors vote by proxy at a meeting?
Yes.
Take a vote. Who says directors can vote by proxy at a meeting?
Or directors, and
Directors. Directors cannot vote by proxy at a meeting. All right, we're distinguishing it. This is a right. Directors cannot vote by proxy at a meeting. Shareholders can. Important distinction. Now, the way you vote is you create a proxy. You appoint an agent in writing to appear at a meeting. This proxy is generally revocable. You can make an irrevocable proxy. Irrevocable proxies are more common in closely held businesses, and they're almost kind of like estate planning documents. Talk about like succession and how things are going to go out over time. But for now, just think about a proxy as someone who's going to vote your shares for you. Now, this is important because it's not. Let's say I have 4 shares of McDonald's Corporation, and for some reason I care enough to vote. Rationally, by the way, I should be rationally apathetic. If I have 4 shares of McDonald's, I should probably ignore everything and not vote. But let's say I want to vote. How do I vote at McDonald's corporate? Well, what's their headquarters, in Wisconsin or in Chicago? Right? I mean, not here. Right? It's not. I mean, the meeting's not going to be in Pittsburgh. Okay, let's start with that. Most corporate annual meetings of public companies are not in Pittsburgh, which means to go and vote at the meeting, I have to literally get on a plane. Now, that may be worth it to some people, but if I have 4 shares of stock, am I going to fly to California or Chicago to cast my 4 votes in person? No. So proxies are useful for this purpose. And yes?
So can a corporation like McDonald's like say, hey, this is the proxy agent we recommend, like all you million shareholders that have one
They
share?
absolutely do. And they even recommend how you should vote. They give you a card in the mail. They say, just fill out this card and send it back. Fill out the green card. Vote for all the current incumbent directors. Deny these precatory proposals. They actually have proxy statements and make recommendations. And I can show one to you next class if you're interested. But absolutely. And then there can be a battle. Send in the green card, send in the red card. But they make it easy for you because they want you to vote in their favor. Yeah. And that, well, we'll get back to that in a second.
When someone starts, they'll call me up and like get on
Yeah.
and like, hey, you need to do it this way, and I'll try and persuade you to something to do.
Really?
Yeah.
You must be a big holder there, right? Every little bit helps, yeah? No, it's interesting. So they actually call you and try to get you to vote your shares, right? Because it is a political campaign. Just like I'm sure I got a lot of calls from people representing Hillary Clinton, or Donald Trump, right? It's not that different, believe it or not. It's like a mini country inside of each company. It's certainly at some of the higher levels where there's higher stakes and it really matters. Yeah, but they'll send you a packet in the mail, and they'll even have it prepaid, and it's easy as long as you vote their way. And now the reason they can do that, by the way, is that the incumbent directors financially control the whole process. And so they use corporate money to fund their campaigns. It's sort of like the issue about whether an incumbent president can use Air Force One on the campaign trail. Do you remember that kind of being a debate? Whether an incumbent president, I think Obama, or was it? I don't remember who it was. It probably comes up with every president. Can he use essentially government resources for his campaign? Well, in corporations, you absolutely can and do. Question?
Are there any rules on where you can hold the meeting?
Not really. Not under Delaware. I mean, you could hold it in Barbados if you want. It's just a question of what the bylaws say, and sometimes there are restrictions in the bylaws. Sometimes they'll say a reasonable place. As far as I know, I don't think there's a statutory demand. And actually, some of the shareholder meetings are like in Cabo San Lucas, and you've got guys flying down there on their Learjet and writing the whole thing off. Trust me. I mean, there's look, there's abuses. As I said, the where does management want to hold the meeting? Yeah, in January in Cabo, and they can use corporate funds to get there, and that's fine. Shareholders might fire them at the meeting for doing this, but the shareholders that show up probably want it to be in Cabo too. I mean, that's a particular kind of company. You won't see that as much with your large private companies. If anyone wants to invite me to a shareholder meeting in Cabo, I'm there, by the way. I won't vote by proxy. Is there another question up here? Okay. In addition, just like we have sort of people who are maintaining the sanctity of the vote, corporations will also probably have someone who's counting those votes. Simple majority and absolute majority. So, and Ms. McGee, we'll keep working on this one, right? We're going to talk about majority simple. So, we have a company, right? We have 100 outstanding shares, right? We have 60 shares at the meeting. We have two concepts. We have the concept of a simple majority and an absolute majority. Okay? 100 outstanding shares, 60 of those shares are at the meeting. What is a simple majority of shares at the meeting?
Is that one would be 51?
Nope. Go back and take a look at your book for a sec. Go refresh yourself on the definitions here, and anyone else can jump in the meantime. What's the difference between an absolute and a simple majority?
Simple majority of the majority of the shares at the meeting.
Majority of the shares at the meeting, and what's the number there?
30.
31. Ms. McGee, how much is the absolute majority?
I'm going to throw 51 back out there.
51, right? 51 is the number, right? Absolute majority represents the outstanding shares. Important concepts to distinguish. By the way, if you want to make a guess, which state requires a simple majority? Which state? Delaware. Delaware requires just a simple majority. Now this means, by the way, let's just pull the math a little further. Well, the state, I shouldn't say that. The states that require an absolute majority often will also have a majority required for a quorum, sort of incongruous otherwise. All right. The absolute majority and simple majority. One share equals one vote, generally, but not always. There's one famous example of a company where that isn't the case. A public company, in fact. Unusual in public company context. What is the famous public company where the founders have maintained voting control? Anyone know? You all use this company today, probably. Yes? Google. Google has a very interesting structure. What is their structure?
I'm not sure. I think I remember reading something in the book about them maintaining.
Yeah, it was in the book, so it's fair game, right? What was it?
Class A shares, you get 1 vote. Class B shares, you get 10 votes each.
Get 10 votes each. So this is a way for Sergey to keep his, position, right? His dominance. And shareholders don't seem to mind. In fact, so this is the crazy thing. Like, Google is super valuable company. Now it's Alphabet, so I don't know actually what's happened since, Google kind of rolled up into Alphabet. Rolling up is a whole nother complicated transaction, well beyond our scope. But, I mean, going back to the days of yore, ye old Google days, the shareholders didn't seem to mind. So, again, let's connect this to our concept of how much do shareholders value control. They have less control over in Delaware, yet most companies are incorporated there. We have these campaigns in order to change the bylaws to give shareholders more control. Yet, in Google, they're just jumping over themselves to pay more and more for stock, as even though they don't necessarily get control from that. So shareholder control and stock value is sort of an important concept. So why do directors get reelected? We talked about this a little bit. This is the breakout box on 352. I mean, 1 share, 1 vote. Why would directors get reelected? We talked about this a little bit. Because they're the ones sending out the mail. They're the ones deciding where to hold the election, when to hold it. It's not exactly a free and fair election when one person has all the money and all the power, and the other side can raise an insurgency campaign. So insurgencies generally fail. In fact, insurgencies, as we'll learn about if we have time at the end of this semester, and they're really interesting to me, often end up in settlements because they typically don't raise the level of getting to a vote that can win. Most shareholder proposals lose, but it's bad publicity for the company. It drives down stock price, and it relates to executive compensation. All right. All right, more terminology, right? A lot of stuff to learn. Hopefully you read closely, or you should reread closely, because this is what the test will be about, this kind of stuff, right? Absolute majority, simple majority. What do these things mean? What is a staggered board? What is straight voting? What is cumulative voting? What is plurality voting? Do we know what all these things mean? I have a brief overview here. But we need to know what these things mean. These are essential concepts of corporate law. You can't act like you know about corporate governance if you don't know what these basic terms mean, right? So we're setting up that foundation here. Critical to understand. This is basics. We're going to get more advanced than this. You got to know the terms. So, simple majority. What's that mean? It means more votes for something than against something, right? When we talk about simple majority, we don't care about how many shares are outstanding, but how many shares actually vote. So we have 30 votes cast at a meeting. Simple majority is 16 of them. Even if we have 1 million shares outstanding. An absolute majority means that half of the stock that can vote does vote. Now this means that in a simple majority situation, somebody always wins so long as at least one vote is cast. But in an absolute majority, you might not have any winner, right? It's possible to not reach an absolute majority if not enough votes are cast.
So then do they stay in by default?
They stay in by default, yeah. At least they're not voted out. It can, or the seats, depending on the operator, if it's a question of voting them out, then they stay in. It's a question of appointing new ones, the seat doesn't get filled. It creates instability. Guess which state requires a simple majority for most things? Delaware, right? In part because while an absolute majority might protect shareholders, it also creates corporate instability. Plurality voting, what does that mean? It means that the director who gets the most vote wins. Majority voting means they need to get more than 50% of the outstanding to win. Again, hard to achieve. Now, whether it's 50% of the votes at the meeting, right? Or 50% of the total outstanding shares. So some corporations, some states, and in fact, corporations are voluntarily taking this on because of a theory that by taking on more responsibility, by giving more shareholder protection, the stock price will go up. And that's based on a lot of research, which I think goes both ways. I don't know how much control shareholders really want. I don't know how much democracy we really want sometimes. I mean, you know, it's not always the case that everybody wants to have absolute control over everything. I mean, part of the nature of corporations and part of the nature of representative government is that abdication of responsibility. It's a constant tension. The pendulum swings back and forth. And what we're seeing in our political culture today and observing those pendulums are relevant to understanding corporate law and how those control pendulums have swung also. All right, these are terms that you should know. I'm not going to go more into it now. Voting rights. So this is now, we're getting to where the rubber meets the road, right? This is our second section. That was our basics. So now, what do shareholders vote on? Fundamental transactions. Okay, next question. What are fundamental transactions? So this is the point I made at the beginning of class. I'll reiterate it here. Fundamental transactions are not what you might think. They are a discrete list of fundamental corporate changes that are specified in statute as requiring shareholder approval or veto. Shareholders cannot initiate these actions. They can only approve or veto them. And they don't have veto rights over other transactions, even though they may seem fundamental from a colloquial perspective. The fundamental transactions are amendments to the articles, as they're called in Delaware, or the certificate, as they're called in most other states, of incorporation. Significant mergers, often defined as usually 20% of the outstanding stock. We'll get into the definition a little bit more, not too much, but not all mergers. Like, if you have a company like McDonald's, right, or take a company like Microsoft is much more acquisitive. Microsoft buys companies all the time. A lot of small tech companies, right? So Microsoft has, I don't know, $60 billion in cash, something like that, a market capitalization, meaning how much their entire stock is worth, of hundreds of billions, maybe trillions of dollars, right? You've got $60 billion in cash, and you go out and you spend $1 million on a startup company that has created some promising new technology. From McDonald's perspective, that's not a significant transaction. It's not a significant merger. It doesn't reach a dollar threshold, doesn't reach a stock threshold. Even if they pay for that merger entirely in Microsoft stock, it's just not enough stock to make that big an impact, right? Not reaching that in Delaware kind of 20% level. On the other hand, is it a significant transaction from the company that's being bought? They're selling 100% of their stock. Yes, absolutely. So a fundamental transaction, you need to look at it as approvals from either side, and we'll have a chart to clarify that. Sale of assets. So asset sales are not technically mergers, but this essentially is necessary because think about it this way. If you needed approval for a merger but not for sale of your assets, then you might say, well, I'll just get an end run. Instead of selling my whole company, I'll just sell everything in it. All the IP, all the employees, all the contracts, whatever. I'll sell all of that stuff. So Delaware got wise to that and said, no. Asset sales of all or substantially all the assets also need approval. And corporate dissolutions. Fundamental change, right? Ending the company. And that's really it. Shareholders must approve these transactions but can't initiate them. Nor do they veto other types of transactions. So what do they all have in common? Again, they are core to the corporate structure of the company. Its stock, its ongoing business nature, right? Its existence, not what it's doing, not that it's selling laptops as opposed to software. So what happens if a shareholder disagrees? What can a shareholder who disagrees with a fundamental transaction do?
So,
One option is to sell, but that actually is only available to certain kinds of shareholders. Let's say that I start a company, right, and I sell you 20% of the stock in my company, and I decide to sell my company to Microsoft, and you don't like the price. Can you sell those shares? Probably not, right? I mean, it's very hard. There's no market for that. You know, Orenburg Inc. Who wants to buy Orenburg Inc.? You know, you don't have what's called a market out. So what else can shareholders do when they can't sell?
Vote no.
They can vote no, right? They can veto. They can vote against the merger. But sometimes that can be frustrating because let's say there's a bunch of different kinds of shareholders. We talked in capital structure earlier in the video, right? We have our Series C, our Series B, our Series A, our common. We're like Series A or something. And let's say the transaction results in, and they have this waterfall concept. The money goes to the highest priority shareholders first. And let's say they got 4x liquidation multiples or something like that on their $25 million investment. We're getting $100 million. Basically, only the Series C are going to get paid anything. We're going to get nothing from this transaction. We're going to vote no, but the Series C and B are going to vote yes, and there's more of them than us. So what if my no vote means nothing? Do I just get hosed?
Oh, you can opt out.
You can opt out, right? And that's the third method. So you can sell. If there's a public market, called the market out. If there's no market, you can opt out through a appraisal, or you can dissent. Although dissent can be useless in many cases, and that's why, so if there's no market and dissent is useless, that's why we have the opt-out option. So this substitutes an exit right for the veto right, and you can force the company to buy your shares at a fair market value, which requires an appraisal process, and again, this means valuing stock that is not publicly traded, which is complicated. The method of valuing non-fungible goods is difficult.
It's kind of like an off-the-track question, but I've never heard of like shareholder dissenting. Does that happen in public companies? Is like is one is like a threat to people for not to do something?
Absolutely.
No dissent, and then once they do, the threat of the dissent, knowing that it'll.
Absolutely. And so what happens in public companies? So America has a weird capitalization structure. Like 80% of shareholders in America are large institutions. The largest that I think it's the largest is CalPERS, it's a California pension fund. And so companies like CalPERS will actually say, we're going to dissent, and we are going to, and they'll create their own campaign, and as a result, try to negotiate for a different deal. And so that dissenter's right is something that, and that's why the notice is important, because it usually invokes an entire campaign, where you're not just going to say, well, I don't like Donald Trump, so I'm going to vote no. Well, voting for someone, it's not quite as clear as that. Right? I don't like Proposition 47, so I'll vote no on it. It's more like saying, I don't like Proposition 47. Me voting no is not enough. I have 30% of the company, and I'm going to find 25% more of the company's shares through other major institutions and a few minor people who are going to say no to Proposition 47, and create a whole campaign and call the shareholders and ask them to vote against it. And if the board feels that there is enough votes against it, they will often just back down and withdraw the proposal. Yeah. All right. Okay, I think that's all we can get through for today. I don't want to kind of push it too far. So we've got a lot to cover going forward. I can see already that many of you have not read closely enough to do well on the exam on this material. This is very terminology driven. You should be familiar with those terms by next week. So when you come back in, make sure you know what all these different voting techniques are. Be facile with them. They are critical to understanding how to govern a company. They will be tested on. So make sure you're familiar with the terms. That is the basics, and we're going to build from those basics next week to understand how different kinds of transactions get approval or not. So make sure you go back through the chapter if you haven't already, and we're going to then move through the chapter and cover the cases. Hopefully some of you feel on a little more comfortable ground as we go through some of the case law, which sort of sets up some of these. Spoiler alert, many of the cases have since been codified into statute, so make sure you look at those statutes and read them too. Reading statutes can be hard, I know, but it's an important skill to learn. And so I think the statute that's most relevant here is Delaware General Corporation Law 141K. Verify that before I... Yeah, you should be looking at, so the appraisal rights concept is Delaware General Corporation Law 262. And the concept, well, I don't know if we're going to get to the Exchange Act rule. And then, sorry, trying to find the right, yeah, 141K. 141K describes when shareholders can vote out directors. And so the case law that you'll read in Campbell has later been codified into statute by that Delaware provision. So when you read Campbell, make sure you also read the statute, because that actually shows you the case is meant to illustrate a principle, and then the statute is meant to tell you what the law is. I care that you know about the principle so you understand how the law operates, but I mostly care that you know what the law is, so that if you are asked a question about corporate governance by a company, you would be able to point to the right direction and understand kind of where the state of the law is. So 141K. A question?
Do you know what the assignment is?
Finish chapter 14.
Okay.
Yeah, read through the rest of chapter 14. You know, I mean, I'm adjusting the pace as we go along based on kind of how responsive people are, but my intention is to cover it. Yeah. All right. Thank you. I'll see you next week.